Welcome to the regularly scheduled meeting of the Oklahoma City Board of Adjustment for March 2nd. If you have a cell phone with you, you might want to turn it down now. And I guess the first thing we'll do is receive the minutes.
Before we do, could I make a correction, please? To the February 16th meeting, case number 4, case number 14326, Jeff Austin was absent for that meeting.
Are you sure?
Positive.
Okay.
Thank you.
All right, we'll make a note of that correction. Do I have a motion to receive the minutes
So moved.
as corrected?
Second.
I have a motion and a second to receive the minutes as corrected. Would you cast your votes, please? Well, I say yes.
I'm Cat.
I'm asking
I don't know.
what is it, 5 or 6?
Hey. I was never appointed as IT chairperson.
Well, we could take care of that now if you'd like. No?
You got to do every one of them?
There you go.
We've got an extra.
Yeah, you guys complain a lot. Okay.
Nobody panic. We've done this before.
There we go.
Thank you, and the minutes are received. Glad we got that out of the way. We have a request for requests for continuance or withdrawals, and I see that we do have a request by staff or applicant, as the case may be, to continue item, and depending on how
That's
your
March.
packet reads, it's either item number 6 or item number 7, but it's case number 14336, and we're going to continue it, I believe, until,
16. March the 16th.
oh, I thought it was going to be April 6th.
Well, we got the notice out sooner than what we thought we could, so we got it on to the 16th.
March the 16th.
March the
So we're going
16th.
to continue it until March the 16th. Is the applicant actually here, and is that okay with you? No? Okay. Do I have a motion?
I'll make a motion to continue case number 14336 to March 16th.
Second.
I have a motion and a second to continue case number 14336 until March the 16th. Would you cast your votes, please? And it is continued.
Item number 1, case number 14330, request of Rudy Construction Company, Inc. for a variance to the requirement that a sidewalk be constructed along an arterial street frontage for any new construction in the I-2 Moderate Industrial District located at 3101 Northeast 63rd Street.
The applicant present?
Tim Johnson here on behalf of the applicant. I understand this is an application to do the dreaded request of not permitting sidewalks or not requiring sidewalks, but this is truly a unique condition. This is an area that is zoned mostly I-2. I know in parts of the staff report it talks about the specific zip code areas and having the ADA requirements being heavy in this area, but there are no sidewalks in the general vicinity of this, and it's mostly industrial uses. There's a very large creek that diagonals our side and the sites to the south, which is Deep Fork Creek. There's a very large trench that is immediately adjacent to 63rd Street that runs the entire length of our property, which is the old downtown air park, or I'm sorry, the old Northeast Air Park. So this has been the home of Rudy Construction for a number of years. They've just built a new corporate office in the front, and they've even investigated and had us investigate the ability to close in this channel. But it's cost prohibitive from the standpoint of it'll take 2 large, like 8-by-6 reinforced concrete boxes to close that in, and it's just not cost-effective for them to go spend $1.5 million to build a sidewalk, to allow a sidewalk to be built on top of it. When this road was widened by the county many, many years ago, they did not adhere to the current drainage ordinances, so we have an open ditch immediately adjacent to the north edge of 63rd Street, which is not permitted today in our drainage ordinance and under our regulations. So this has been there, it's existed, it takes a lot of water and drains it down to Deep Fork Creek. To place the sidewalk anywhere near the street, it would be 50 feet back into my owner's property to make that work. And they've got a parking lot there, they've got a construction business that deals with a lot of construction traffic, and we think it would be a safety hazard to put that there. Continuing, so this picture I just put up there is looking west. This is looking east from where our driveway is, and you can see that there's a bridge. There's not enough room on either side of that rail to put a sidewalk across the bridge or approaching the bridge. We have that channel that runs through the property. And as you continue east, the other I-2 piece that is east of our land, there's a small piece right next to the creek that's owned by a contractor, and then east of that is an 80-acre tract that's owned by another contractor, who happens to be the contractor that's building the 235 and I-44 interchange, and they'll be hauling dirt onto this very low site. But you can see, here's 63rd Street. It slopes immediately off to the north about 12 feet. There's no place to put a sidewalk there either, and that's east of our property. So even if we were to manage to put our piece of sidewalk in, there couldn't be any connectivity anywhere. And like I said, it's all industrially zoned. There's a concrete plant where you see SPUD 669. That is a concrete production plant. It's just it's one of those unique cases that it's just impractical and almost impossible. Nothing's impossible, but it's impractical and almost impossible to plant a sidewalk that could be usable by the traveling public in this area.
Well, you have put your finger on exactly the issue. With respect to most of the application and the supporting arguments for it, I was unpersuaded. But I would like to hear from Public Works. And for me, the question comes down to, no one from Public Works is available to speak on the sidewalks. Bummer. So the question really is about the feasibility. I went out and looked at the site. It looked to me like there was room next to the curb. You've been doing this a lot of years, Tim. Talk to me about why you just can't make it happen. You'd think if anybody could do this, it'd be Rudy Construction. So.
And that's what they do. They're not opposed to putting sidewalk down because that's what they do for a living, obviously. But and I'm serious about the fact that they did have us look very hard at how do we close this in and make this a better looking front door, and it was just practically impossible. 63rd Street's going to have to undergo a major reconstruction. The bridge at Deep Fork and 63rd is way undersized. Water goes over 63rd Street. It's just it's a project that will need to be done probably under a bond issue at some point in time.
Well, let's say that your application were denied, and so you were thus required, in order to move forward, to put the sidewalk in. Where would you put it?
They'd have to come up with some pedestrian pathway, I would assume, that would take them up adjacent to their parking lot, where their employees come in and park. She had the site plan up there a minute ago.
I'm looking at an aerial, it may very well be old, but the parking lot you're referring to, it looks like they've got some construction materials that were stored on what would be the east side of their property. That kind of might come within that 50-foot area that you were talking about. Where the employees' parking looks like dirt. Has that changed?
Yes, it's all paved.
Okay, so this is an old aerial. When was that done?
That work was just completed in the last few months.
Okay.
I mean, they've done a really nice job of renovating the site, I think. And to me, this would be part of this. If we were to permit the variance, I think I would want it conditioned. You know, if 63rd Street is upgraded or widened, it is apparent from my very non-engineering perspective that there is not any room to put a sidewalk across that bridge. I mean, there's just nothing
is correct.
there. But if 63rd Street were, improved, widened, whatever, or if the drainage down through there were improved and it became feasible, I would want to see that done. I don't care whether you think it doesn't go anywhere, because eventually we're all hoping it will.
I understand.
But,
And we'd be happy to add that as a caveat to the approval. And it may be these guys that improve that channel at some point in time, but we've looked at it recently, and it's just not feasible.
I don't even know that we can create that condition. So the condition that you're putting forth would be that if the city comes through and makes those improvements or widens the road, improves the drainage, that then at that moment they're going to be required to put a sidewalk in?
the variance would be, conditioned upon the, continuation of the existing physical conditions. And if those change, the variance would lapse, I would think. We've done that before.
We have?
I think we've conditioned it on use specifically, but I think that for city projects, frequently city will itself put the sidewalks in if there is a larger project.
I also agree with Madam Chairman as well. There are some places out there on 63rd, some of the newer construction as you go along, that there are sidewalks. And
West of I-35.
Right. And I think it's important that there be sidewalks, and I understand your problem. I would like to somehow condition this so that insofar as the configuration of that street until it's widened or drainage improvements put in place, that you would agree that it only be conditioned so long as the street remains in its current configuration. But I don't know if I can, Counselor, can I do that?
I think we could maybe do it for a certain period of time, or I don't know that there would necessarily be how that might be enforced.
I thought previously we had conditioned it based on a zoning.
Yes.
That's the only condition I can recall we ever have put through. So that's why I was staring at you awkwardly, Laura, because if there's other conditions that we can use, I'm not aware of them, but I certainly don't want to condition a variance that the condition is faulty either. That's not good. So, but the use here, that keeps it from being technically perpetual. But how likely is the use to change from this? I don't know that it's very likely anytime soon.
In the past, they've conditioned it on a time frame where it has to be brought back and heard again. And if it changes, then sidewalk would have to go in.
I don't remember us putting any time frame. It was simply, so if this area, in the future years becomes something other than an I-2, or if the city widens and improves that street, they'll do the sidewalk, am I correct?
Generally.
And then if the use changes, if the zoning changes to accommodate that new use, at that point, the requirement for the sidewalk is enforceable.
I think I'd like a more definitive response. Would you be willing to give us a couple of weeks on this, Tim?
Yes.
Let us look at it and see if there's any way that we can, I think, like I said, it's pretty clear that it would be extremely difficult, if not impossible. And the fact that your client is a construction company makes it maybe a little less impossible, but I don't think it's necessarily appropriate for us to require something of them that we wouldn't require of someone else, just because
we would
that's what
agree
they
to
do for a living.
2 week.
So if I could have a couple of weeks, I think I
Absolutely.
would like to do that. Can I get a motion?
I'll make a motion to continue case number 14330 to March the 16th.
Second.
I have a motion and a second to continue case 14330 until March the 16th. Would you cast your votes, please? And it is continued. Thank you.
Item number 2, case number 14333, request of DPI Development LLC for a variance to the platted limits of no access along Northeast 150th Street located at 140 and 160th Northeast 150th Street.
Would you give us your name and address?
Hello, I'm
for-
Don Kasperite, DPI Development Company.
Pull that around so you don't have to lean in. Thank you. Will you tell us about your application, please?
This is a new construction site, northeast 150th between Santa Fe and Lincoln. This area has become a home improvement area. The project that we're wanting to build here is a paint company. There is a appliance store, furniture, a couple of interior decorator types, swimming pool. So it's becoming that. Of course, that's why our paint company likes to be here. If you can notice, on the building on the right has a truck dock on it, and the access to the building for the semis delivering paint needs to come down from the north to back into that dock and then exit back to the west. If this driveway is not there, then it might even keep them from being able to come there. And this, one thing that is nice, this is a paint store that's moving from Edmond to Oklahoma City, so that's a sales tax benefit, and most of the customers are actually Edmond citizens. So there are in the half mile between Santa Fe and Lincoln, there are 6 driveways. There are no access restricted places. These are the last 2 lots to be developed in that section. Everything else is developed, and like I say, there are driveways all along, and I've talked with Jeff Hines and JJ at Planning, and our driveways meet all the distance requirements, so it's totally within the standards that they would ask us to do.
It does. We're satisfied about that.
It does meet the distance from the corners, yes.
Well, the fact that there are driveways all along there is kind of part of the problem, I think. Our staff report indicates that that there's a center median there, and that would...
Well,
really-
actually, the median won't give us any trouble because there is a crossover at the street. And most of the trucks would come from the other direction, but if they did, they could turn south into Santa Fe Crossings, that's a cul-de-sac, and come back up and have a right-hand entrance. So the median actually won't create any issues,
Okay.
since we have the crossover at the street.
Is there anybody else who wants to be heard on this matter today? Members of the board?
I just think, you always are trying to be cognizant, and when you have all these entrances off 150th Street, I think the speed limit's probably 45, and everybody drives 55. And it becomes a hazard in some cases, the more you turn in and out of these places of business. If the speed limit was 30 or 35 and you had slower moving traffic and you have good sight lines, then I think it's less problematic. But I think this is the reason, that they, that
Well,
you're here.
what will happen, if that happens, there'll be industrial uses that will site in, and we won't have any retail tax on them. And my point, I guess, is whether these are or not, it's the condition of driveway access is all along this half mile.
And I understand that. I'm just, I'm playing devil's advocate and saying, when you've got relatively fast-moving traffic and people that are particularly trying to turn across traffic, and the more of this you do, it just, the hazard, the risk goes up in my eyes. I'm not saying that it's, you can't justify. I mean, we want your businesses to be successful, and we want customers to easily access those places.
I'll make a motion to approve the application.
Before I get a second, have we limited in any way the number of drives that we're talking about here? Do we know how many curb cuts we're really talking
On
about?
the south side, there are 6, and Edmond is across the street. There are numerous there also.
I mean that you want.
I'm sorry?
That you want.
There's one on each side of the street. The one that, this is to the one she has up now is to the west of Santa Fe Crossing. This one here is 2 uses, but it's only one driveway for both.
Okay.
So like I said before, our separations are well beyond the minimum.
Okay. But you are going to go ahead and take access also onto if I'm looking at this correctly, onto the Santa Fe crossing.
Yeah,
drive.
basically, it'll just be, you'll have two uses in one driveway for each. The truck exit will go down there where it says Lot 24. They'll come in from the north, back in, and then exit there. So we'll have no backing in of any trucks with this configuration.
I have a motion. Do I have a second?
I'll second it.
I have a motion and a second to approve case number 14333. Would you cast your votes, please? It's
Thank you.
approved.
Item number 3, case number 14334, request of Brahms Ice Cream and Dairy for a variance to the maximum size of attached wall signs in PUD 78B district, located at 10920 North Rockwell Avenue.
Would you give us your name and address for the record, please?
My name's Harris Wilson. I'm the Site Development Manager for Brahms Ice Cream. The address is 3000 Northeast 63rd Street.
Would you tell us about your application?
We're rebuilding the store there at Rockwell and Hefner, and we've turned in a sign permit application for the signage you see on the building on the screen. We're asking for an additional sign at the back on the drive-through side of the building, a Brahms 28-inch, I think it's 12 feet long, sign that will face the shopping center to the east of the building. And then on the northeast corner, on the drive-through side of the building, where we have Brahms hamburgers, we're asking for an increase in size to the hamburger sign from a 16-inch tall hamburger to a 20-inch tall hamburger, just to get a little bit more visibility for the signage.
Does that represent a change from your normal signage package for your new stores?
The normal signage package is what you see right there. We have on the back of the building, on the drive-through side, we ask for that where we have visibility. If that was houses back there and, a neighborhood, we wouldn't want to put a sign up there. But since it's a shopping center, we like to have that there to let people know, if they don't know who we are, that we're there. On the hamburger side sign, we're just asking for an increase in size. We believe that it just helps with our advertising.
How many stores currently have, I think what Mr. Austin's getting to, how many stores currently have this signage package on them, including the word hamburgers?
That's a hard question to answer because we've been going through and updating where we can. This building is the latest model that we are constructing. It's called a Brahms XL, and it's we probably have 15 of these in the inventory right now, so that's the standard sign package for that particular building. On the older models where we have signage, we've been going back on the front of those buildings. For instance, the one at May and 63rd Street, I think that's a Q model, and we've been adding we want to add hamburgers on buildings like that, hamburgers and Fresh Market to the left and right of the main entrance.
So what you're saying is that the signage package you've designed for this store and others like it would fall within the ordinance restrictions, but for the fact that this doesn't back up to a neighborhood, so you've added signage to the area that fronts the shopping center. Is that correct?
Yes. We're asking for an increase in the square footage that we'd be allowed to put on this building above what the current ordinance would allow. In other towns, if this were, say this was in Kingfisher, they allow more signage on the building, and that's what you would see if we had a similar situation.
I think what he's looking for is something that would make this application unique because of the exposure where you want to increase the size of your signage. If that side backed up to a neighborhood or something like that, then this request would be unreasonable. But I think, maybe we can consider it. The other thing, too, is this brand is so well established in Oklahoma, I don't know of anybody that doesn't know what a Brahms. And your identity used to be, you were an ice cream and milk store, and I know, the Fresh Market and the other food service items that you sell. That would be the consideration for me is the additional exposure back to another retail area where people there could easily identify, the restaurant and what they're doing. But if they wanted to do it, where it proximity and backed up to a residential area, I think, it would be pretty easy to ask them to do something else.
I also, I drive by that area a lot, and that particular shopping area gets kind of confusing, and people are driving along in the area, and there's a lot of traffic, commute traffic coming back and forth, and I think that the design appears to be tasteful and in line with the logo, and in consideration of the fact you're not backing up on the neighborhood, I think it would be appropriate, and I think that staff even made that notation on the favorable considerations.
Is there anybody else who wants to be heard on this matter today? For my little 2 cents worth, I guess, I don't find anything unique about this site. I don't find anything peculiar about it, or, the staff report indicates that the code would appear to allow adequate signage, and I think that's true. What I hear you saying is that this is your standard sign package, so, every new Brahms is going to need a variance, and that's a problem for me. So I can't support it, but I'll take a motion.
I think what we're saying is that the location, the proximity to another retail center is what makes it unique, as opposed to a restaurant that is more aligned next to a residential area or things like that. So for visibility from this large retail area, for people to easily, find the restaurant. But it's like I'm telling you and him, if this backed up to a residential area, I would oppose the application.
The only additional signage that we're asking as far as a new sign is the one that's facing the shopping center. We can have 16-inch tall hamburgers underneath the Brahm sign. We feel the more visibility we have, the better we do.
I get that.
I'd move approval.
I have a motion and a second to approve case number 14334. Would you cast your votes, please? And it is approved.
Thank you very much. I appreciate it.
Item number 4, case number 14335, request of City Glass Vintage Reclaimed Lumber for a variance to the maximum size for attached wall sign in the I-2 Modern Industrial District located at 1125 Exchange Avenue.
Hi, my name is Bob Adamson, and I'm the owner of this business located at 1125 Exchange.
Could you tell us about your application, please?
Yes, the application was for the size of the sign that was painted on the side of the building. We're one of the only retailers on Exchange. Exchange is a little bit of a convoluted street. It starts at Western and Reno. We're a block west of that. If you're not in the correct lane, you cannot even access Exchange. So this sign allows us the visibility to perhaps see where we're at before you get totally to the intersection. We have a lot of customers that come by and are frustrated because they have to go around 2 or 3 blocks to finally work their way back there because they've missed this turn. So we really need that visibility. The other thing that makes this a little more complicated is I understand in a couple of years that Exchange is going to be shut off at the corner of Reno and Western, and you're actually going to have to go down, come around on 3rd, and come in. Right now it's a one-way street. At that point it's going to be a two-way with a turnaround. So without that visibility, our customers literally cannot find us. We're a new business. We've been there about a year. What you're seeing right there is actually, that's if you're at the intersection of Western and Reno and you happen to be in the turn lane, then you can navigate that turn. If you're not, you've lost the opportunity to come down Exchange.
Okay. I was a little confused because our staff report refers to this as an existing sign, but it's one that's been painted fairly recently.
Yes, this property used to belong to Brown Machinery for 30-some years. Their name was painted on the side of the building. We painted over it and added this mural to, which we believe is very tasteful. And this gives us the extra.
mural you're referring to, is that the flag portion? Is that what you added?
Yes.
So before that, there was an existing sign there in that same sort of block, if you will, at the top of the brick?
Yes.
How long had that been there?
30-some years.
Is that counted on their sign? I mean, does the flag create the extension? Is that the reason that it's 383 square feet?
It is counted as part of the sign.
Okay.
And that's because if it were a mural, there's a process that you have to go through to get approval for that and so on, right?
Yes.
Okay. Is there anybody else here who wants to be heard on this matter today? Members of the board? Questions, comments, motions?
So Southwest Third will become two-way instead of one-way, and then they can drop south off Reno on Klein.
Right.
And find you that way. I'm fairly familiar with this part of the, and it, you know, for them to access Exchange headed south on Western, you have to be in the western lane to turn. So, I mean, we want you to be successful. You know, we grant this variance, and you've essentially made it hard, you know, for the other businesses, and I'm sure on the other side of the street, that's probably going to develop too. And this is one of the things that, you know, even though we hear and consider these individually, if they know you've done it and gotten a variance approved for that, it's because all businesses want that visibility. They want to be able to be found easily, and that's my only concern. I'm you know, not in favor of painting over the image of the American flag. You know, it's tasteful and it looks good, and I want your business to be easily found. But those are my concerns. Is that, you know, I want your business to be found. I want it to be visible.
Did you, just out of curiosity, what prevented you, or why did you not go through the process of getting approved to paint the mural?
Well, we were, quite honestly, we were a little naive. The painter that actually painted the original Brown sign came to us and offered to do this and convinced us that it fell within, that it would actually fall within a mural and that it wouldn't be a problem. So that's kind of how we got here from there. My partner was actually much more involved in this than I was. He left a couple months ago, so I kind of picked this up from there. Now, we did go before the Riverfront Committee, and they did approve it, if that has any bearing.
Question for our municipal councilor. So if we approve this, if we were to approve this variance at 383 square feet, given that it's a mural, then essentially at some point somebody could come, sandblast a brick off, and put up a 383 square foot sign.
I think that this hasn't been interpreted as a mural, essentially, because it didn't go through the Arts Commission and all of that, I don't believe. But it's an artistic graphic, which is defined a little bit differently in the code. But I think if the board were to grant the variance, they could specifically say for this number of square feet, but it wouldn't be for content. They'd be allowed to do maintenance and those kinds of things to this, but I think they'd also be allowed to change it unless that were, that would be very difficult to enforce.
Riverfront did review it, is that correct?
Yes.
Right, so if they were to make changes, that would also have to go before the Riverfront Design Committee.
And we presented changes in that meeting, and they elected to leave it like it was.
Well, I drove Exchange, I go there because sometimes I go to Cattleman's, so anyway, off Western. And it's very complicated when you go down Exchange. You could even be looking for it. You could even have your navigation trying for it. And it's very complicated. And so since it's already been reviewed once and it's passed that muster, and staff noted that the one-way street would make this difficult to locate, and eventual closing could make the building difficult to locate, and for all those bases, I could support this.
Let me just say, also, this signage does not affront, it does not face Exchange.
No, it does not.
It faces the east, and so it is, if you were traveling westbound on Exchange from the access to Western at Reno. So when that is closed off too, this side of your building is going to be less visible because, am I correct?
That's correct.
So when they drive Exchange up toward Western, they'll no longer be able to access Western at that point, and there'll just be a turnaround?
That's my understanding.
Okay. I'll, with reservations, support the application.
Is that a
Have
motion?
It is a motion to
Second.
approve the application.
I have a motion and a second to approve case number 14335. Would you cast your votes, please? It is approved.
Okay, thank you.
Item number 5A, case number 14332, motion to dismiss the appeal of Sosa Neighborhood Association regarding the approval of Revision 1 corrected, certificate of approval, UDCA 1500013 by the Planning Department staff concerning property located at 817 Northwest 6th.
Madam Chairman, I believe my law firm is involved in this in some way, so I am going to recuse myself.
We'll let you do that. Mr. Box.
Donaldson, exit. Good afternoon. David Box, 522 Colcord Drive. I am here today on behalf of the developers of this site, Mr. Vincent Lee and Ms. Kayla Baker. This is a bit of a strange action to be before you. This is the second time the board has heard it. Ms. Powers, this is now the fifth time you will have heard this case. And what we have here is a motion to dismiss. We believe that the appeal that was filed untimely, and therefore this board lacks any jurisdiction whatsoever to hear the appeal filed. What I have are two exhibits. On my right is what is being called revision number 1. This is the CA that was amended administratively by staff. It was approved on December 19th, 2016. It became effective. This says January 5th. Our calculation is January 5th rather than 6th. Either way, we can call it the 6th. January 6th came and went, and no appeal was filed, despite the neighbors constantly barging into staff's office, constantly asking them what was going on. They failed to file an appeal. They did identify one thing. If you look at revision number 1, there are 11 items that were approved in this revision. Item number 1, narrow the project driveway from 24 to 22 feet. It was determined by staff that they didn't have the right administratively to amend the CA on that topic. So what they did, they created a revision number 1 corrected. This was approved January 9th, again, after the appeal time. The only thing that this document did was delete item number 1 in the revision number 1. No other legal effect whatsoever. So these are the same 10 items. Now it's items 1 through 10 rather than 2 through 11. The only legal effect of this document from which the neighbors now appeal is that item 1 was deleted. That means in order to appeal the 10 items that remain, they needed to do so by January 5th in our calculation, January 6th according to what the revision number 1 actually states on the face of it. They filed their appeal January 24th. Now, perhaps more troubling about this is corrected revisions to CAs are not uncommon. The process to revise a CA is not uncommon. In fact, there frankly be no efficient way to develop property. Once you start turning dirt, things change from what was originally approved. There has to be some leeway within staff to have some minor amendments. It's very similar to a PUD. A PUD can be approved, and then there's a process to administratively amend it with minor revisions. What we did was we filed an open record request in order to see how other corrections were handled. First one I'm going to show you, what we're calling example 1, is DTCA 1673. This is almost identical and on all fours to what we have. Here's the original CA. Here's the corrected CA.
Pardon me, Chairwoman, I have to object to this. I specifically asked Mr. Box for exhibits and witness lists last week. I was provided with nothing. I don't have a copy of what he's presenting to you. This is improper on a motion to dismiss.
Well, there is no there's no function to request witness and exhibit lists at the Board of Adjustment.
Nevertheless, I did so and was completely ignored. Now he's... Yes. I apologize. My name is Clint Cowan, 812 Northwest 8th. I'm also an attorney at Feller Snyder. I wrote Mr. Box a letter last week asking him for exhibits and witness lists of everything that he would present today. That letter went unresponded to. I don't have a copy of anything he's trying to present to the board, which I'm entitled to have a copy of anything he's submitting to you. And so I object to the submission of all of these documents, and even in demonstrative form.
Well, these are attached in his notice of appeal.
That's right. I have no objection
I find
to
that
that.
hard to believe. Likewise, if he believes that there is some requirement that witness and exhibit lists be exchanged, we have yet to receive one from them. So,
I'm not putting on any witness or exhibits.
I think Mr. Box is correct that we do not have procedures in place that require these kinds of exchanges. There's not a discovery code that's applicable here. And frankly, to me, it comes down then to a question of fairness. On the one hand, I suppose there's a more specific question, a more narrow question of whether it's appropriate for the evidence to be presented here for the first time if we haven't seen it or if it hasn't been provided but to staff for review or whatever. But I think more generally it's a question of fairness, and I think that's just going to be a judgment call for the board. Are we comfortable receiving and deciding a case based on evidence, exhibits, whatever, that have not been provided to the other side? And I'll listen to the board members on that question before we go any further.
and if I could, they filed an open records request, and I believe there were some 6,000 documents produced. These would have surely been within those documents produced. So
They were not, and regardless of whether we filed an open records request, we're entitled to documents that our opposing counsel wants to submit before the board. Your bylaws actually state in section 7.2, the clerk shall email in PDF format copies of all written documents relating to a pending board case that are filed by appellants, applicants, protestants, or others no less than 4 business days, but not less than 1 business day before the public hearing on the case, with such copies to be emailed by the clerk to board members within a reasonable time after the filing thereof. Now, I would submit that we should have been entitled to see those documents as well, and I don't think he submitted them to you within the time frame required in your bylaws.
I think that's, the last part of that at least is a correct statement. They're being presented here today for the first time. So if you'll give us a minute, I'll hear from the members of the board on that particular question.
I will make a comment. Regardless of all of that, Mr. Box, I don't think the other documents that are not pertinent to this case really are going to affect the ruling on this case, so your motion to dismiss. It has to stand on its own. So I think the document we would be looking at for this proceeding on the motion to dismiss would be the documents of the CA and the corrected and the revised CA. And what has happened in the other matters, I don't think would have any bearing on this one. I think we need to look at it on its face. So for whatever reason, I would not think we would necessarily need to go further on that document. So.
And I'll tell you, the only purpose for which I was, and I don't even need to show you the document, the only purpose I was showing it was to show in the past, when staff has corrected CAs, they don't alter the effective date because staff has no ability legally to crawl back and reopen an appeal period.
Here they did alter the effective date.
Other members of the board, comments?
I think the problem that we have is that in the past, Mr. Cowan, we've tried to be, in an effort to be fair to all the parties, we've tried to, if things have come up that the board needs to see in order to render an effective decision, because this is sort of the last stop on the tour before you go to district court, we've tended to allow that. I think your acknowledgement of our bylaws is on point, so procedurally we have a problem there. I think there are other ways that we can get the information that Mr. Box is trying to report to us without looking at evidence. If you got people who are going to object to that being a part of the record, given that the procedural aspects of that weren't followed, it's a problem.
I won't show it again.
Thank you.
Thank you.
Okay. So what we have, and what the response to my motion to dismiss seemed to argue, was that staff somehow promised them that they were going to reissue a new CA, a corrected CA, that would somehow open up an appeal window. Legally, if staff told them that, they were wrong. Staff cannot do that. Once an appeal time runs, it is over. 11 OS 44-1092 says the appeal shall be taken within the time limits as fixed by municipal ordinance. The time limit fixed by the ordinance is 10 days.
What ordinance are you quoting from there?
What ordinance or statute?
Well, the statute I have in front of me, what you just said was an appeal shall be taken, and I'm reading from 11 OS, says an appeal shall be taken within the time limits as fixed by municipal ordinance. What municipal ordinance are you going to use to substantiate that 10-day period?
59-4250.3 sub C sub 2. No, excuse me.
I'd like to ask municipal councilor on that provision for sure on that.
Give us a minute. It's in chapter 59. But the reason it's 10 days, it's confirmed by the effective date of the CA. What the effective date... Okay, so it is 59-4250.10 sub C. 4250.10 are appeals. Half the way through C, it's or 10 business days if within the Bricktown Core Development District, Downtown Design Districts, DBD, DTD1, and DTD2. So it is 10 business days, which is why the effective date is set off to January 6th, because we had holidays that intervened in that time. So 10 business days in which it was when they had to file the appeal. They didn't do it. The ordinance is clear, state statutes are clear. Once those 10 days run, it's over. It'd be similar to a PUD. A PUD would be approved by the city council. Say somebody went, or say sort of 30 business days runs. That PUD is final, those rights have vested.
Hang on one second.
Yes, sir.
Laura, the cottage district, which isn't real by ordinance, okay? By ordinance is effectively within the DTD 1.
Correct.
Is that correct? Okay.
I'm not sure I understand what you mean by that statement, that it's not real.
It's not a recognized district that's defined within the code. You have to, we've run into this many times on variances from issues governing the regulations there, and we've always looked to the DTD1 to get those regulations. So because the cottage district is not defined under our ordinances, I'm trying to make sure that I know, especially since there's some confusion in the file about urban design versus the downtown design review. I'm just trying to figure out exactly where we are by definition, by ordinance.
Again, I don't think I agree with that characterization.
Can you direct me to the cottage district?
The cottage district is set out, its parameters are defined by, a legal description. Let me see how quickly we can actually locate it.
Correct, but what the code then says is, it instructs on what you use in terms of applying, like in here, appeal deadlines. There's no different appeal deadline in the cottage district than there is outside of the cottage district when it comes to this. I mean, it's 10 business days.
I agree with that statement as well.
You don't agree with that statement?
I do.
Oh, okay.
I just think it's important that we're clear, because if there's going to be variations or arguments about which ordinances is applicable, which time periods are applicable, and where we're looking within the code, I think we need to first ensure that we're looking at the cottage district within the right set of ordinances. So if the DTD differs in some way from what the ordinances on urban design are going to say to us, I want to know which ones are applicable, because there are no ordinances specifically on point that address the cottage district.
Well, I wouldn't say there are no ordinances that address the cottage district. It is defined. It is defined by a legal description. It is part of the DTD 1. It is subject to review by the Urban Design Commission. All of that is set forth by ordinance. So,
just need an ordinance.
May I speak? In the Zoning and Planning Code, Chapter 59, Appendix A, the cottage district is described under subsection E as cottage district. This area is not in the Urban Design Overlay District, but it is subject to review by the Urban Design Commission under the DTDL1 criteria. And it refers to 59-7200.3.B.1a for the legal description. So it is actually in the code at that point.
For the purposes of what I'm arguing right now, though, it matters not. It's 10 days, 10 days, 10 days. If we have to get to the merits of the case, which legally we do not believe you have the jurisdiction to do, we can discuss that. I mean, at a minimum, the code is murky as to how the cottage district is handled, what the review is, and what is not. So, December 19th, when the CA was issued, the ability to appeal the 10 items that remained ran. So the only legal effect, the only thing still remaining appealable on January 24th when this appeal was filed was the deletion of number 1. Narrow the project driveway from 24 to 22 feet. We're okay with that. We're abandoning that. But the 10 other items, you cannot legally claw back an appeal window and allow neighbors to come in and stay my client's ability to develop, which they have done, because they relied on staff that they were going to issue a corrected CA. There's just nothing in the statutes or the ordinances that would allow vested rights to reopen because there was an error in something that was approved. Again, at most, the only thing that could be appealable at the date in which they appealed was the deletion of item number 1. And that's it. We think the law is clear and on point. The board lacks jurisdiction to hear this case on anything else other than perhaps item number 1. But item number 1 wasn't in their statement of the case and wasn't appealed. And with that, we would ask you to dismiss this case in conformance with the law, the statutes, and the municipal ordinances. I'd be happy to answer any questions.
Can you point to something in statute or case law that indicates that the approval of the CA created a vested right, as you refer to it? That terminology is kind of specific.
Well, when a CA gets approved, you then have, in the window runs, it's no different than a PUD. You have the legal right to go develop pursuant to that. I mean, think about it in terms like this. Let's say they waited 5 years. If they waited past the appeal time, they can't come back in, re-enter the appeal window, and put the rights that we have to develop on hold. The statutes say an appeal shall be taken within the time limits as fixed by ordinance. The time limits fixed by ordinance are 10 days. So if they file it on day 11 or day 10,011, it's the same legal effect. My client then has the rights. And the vested rights are the same as a PUD.
I don't like that analogy, but I'm also guessing that your answer to my question is no. You don't have specific case law or statute that refers to the right to develop as vested right.
Well, I didn't set out to research that because it's, to us, the law is crystal clear. When an appeal time runs, the rights vest. You get those rights. Whatever was approved in a CA, once an appeal time runs, you have the legal right to go develop the project in conformance with the approved CA. It's undisputed. There's probably not case law on it because I don't know how you could challenge that.
Okay. Do any of the members of the board have questions of Mr. Box before we hear from the appellees? No, I guess it's the appellants.
I do just want to clarify what I was after, and I think, I'm sorry, first name's Clint, is that right? Yes. To Mr. Clint Cowan's point, John directed me to the appendix, okay, 59-7200, which recognizes the Cottage District as being a part of DTT1. What I was trying to get to is, in this subpart C of 4250.10, subpart C, this authority and execution, it says such appeal shall be taken within 30 days from the date of the decision, or 10 days if within, and then it lists some specific districts, of which the DTD1 is one of those listed. So I was just trying to make sure nobody was confused that even though the Cottage District falls within the purview of urban design, it's a part of the overlay district known as DTD1. We all, I mean, okay.
Anybody else?
Thank you, Chairwoman. Again, I'm Clint Cowan, 812 Northwest 8th Street, and an attorney with the Feller-Snyder's law firm. We filed a response to Mr. Box's motion to dismiss, and our position is very simple. Mr. Box has admitted that the staff has the authority in his mind to revise the certificate of approval. Well, if they have authority to issue it, they also have authority to withdraw it, which is exactly what we were told by city staff they had done. They withdrew the December 19th decision almost immediately after issuing it, and we were told a new decision would be forthcoming in the future.
I'm sorry, when did you get word that the December 19th order approving it had been revoked by staff?
It was within a week or two, I believe. And I don't know for sure, so I can't give you a specific date, but it was around that time.
They're not denying that you received notice after the first...
Oh, no, we're not denying. We were actually told by staff that we should wait until January 24th, when this new one was issued and run, to appeal then on the new revision, which was issued January 9th.
That's not before us today, what you're talking about, that you were told by staff.
Well, it is on the motion to dismiss because Mr. Box is saying we missed our appeal deadline, and we're saying we did not miss our appeal deadline.
Okay. The first revision
Yeah,
had on it an appeal time, is that correct?
that's correct.
And what was that appeal time?
It was 10 business days.
Okay, and what date would that be? Would that be January?
January 6th, I believe,
5th
because
or
of the
6th?
holidays, yes.
So the parties are not in dispute here as to what the appeal time would be with the first revision, correct?
That's correct.
And Mr. Conner, what would be your, just so I understand, what would be your position if that had not been revoked? Would it be, are you in agreement that after that, on January the 6th, if no appeal had been filed, that your ability to appeal any part of what was approved by staff would be foreclosed?
Well, yes, in that we couldn't appeal the decision that had been withdrawn, but that doesn't stop us from appealing the new decision that was issued on January 9th.
So your basis of argument is that because staff revoked its own, essentially its own approval, and then came out and reissued it, that's what started this clock, which we agree is the ordinance on point, right? I don't want to put words in your mouth, but
You're exactly right.
4250.10 subpart C. Okay.
Yes.
All right.
So Mr. Box rightly pointed out that it would be unfair for his client to rely on what city staff told them about when they could and when they couldn't do certain things. Well, we also relied on city staff, and we're told that we should appeal the January 9th decision, not the December 19th decision, which is why we waited until the revised corrected decision was issued on January 9th and appealed that date. We have emails from city staff to that effect.
I have a question, several
Yes.
questions. Number one, it was not called revoked, correct? There was no language that said the first one was revoked.
I'm not aware of any.
Okay, and also on the top of it, didn't it say corrected? I don't have it before me, but I believe.
Oh, you mean the January 9th one? The
yeah.
second one?
Yes, the second one.
It did. It said corrected.
It said corrected. And in what way did the first one and the second one differ? Can the parties agree that the only delineation was item number 1?
Substantively, but I disagree on the time frame for the appeal that was listed.
Well, let's strike that part.
Okay, yes.
So you can agree that the only thing that was different, other than the time for appeal on the bottom after the signature line, was the item number 1.
That's correct.
So if it, you could have delineated item number 1 and it's gone 2 through 11. So instead of 11, it became 10. Is that correct?
Well, that's correct. The numbering was different from the December 19th revision. So instead of being 2 through 11, which it would have been if 1 was just deleted, it went to number 1 through number 10. So the numbering system was changed as well.
Okay.
And with regard to there being a vested right, there's nothing that gives Mr. Box's client a vested right because a revision to a certificate of approval is issued, certainly when it's withdrawn by city staff. We have case law from Connecticut that we'd be happy to provide if the board would like to hear it, where the Supreme Court of Connecticut found that waiting until a second revised issuance of a similar type document did not stop the appellant's ability to appeal that second revised one within the time frame that was listed on it. And this January 9th decision, the corrected revised certificate of approval, said we had 10 business working days from January 9th to appeal it. And that's what we did. We met the time frame for that.
How does staff revoke an approval?
Ms. Cronister, will you come and address us, please? Have you ever revoked one before?
No. Lisa Chronister, Planning Department. I'm manager of the current Planning and Urban Design Commission, and Urban Design Division. No, since I've been here, we've never revoked a CA. There's no, we don't have any process. We do issue occasional corrected CAs to, sometimes there's typos on the date, sometimes there's typos on the scope. We do issue those as necessary. It's not very often, but it does happen. But there's no process that we know of to issue a revoked.
So let me ask you, the appellants, rely heavily on the fact that in their discussions with staff, they were told that the original certificate of approval amendment was being withdrawn and a new one issued. And I don't want to necessarily pin you down about whether you advised them to wait and appeal the second one, but in other words, they believed that the original amendment was revoked and a new one issued based on the response that you gave them to that question. And is that essentially correct? Was it your view that it had been withdrawn and a new one issued?
It is my view that a new one had been issued.
Okay.
But I truly don't remember all the details of all the conversations, and the way the corrected CA was issued with that one line struck does make me think that my only intention was to change that item, because nothing else about any of the rest of the items changed.
Well, but let me, so that though wasn't a typo, that was a material change to what had been approved before. I mean, that was a difference in what, on the December 19th.
Yes, that was more than just a typo. It was after the public noticing of the original CA, it was brought to our attention that the applicant the applicant's purpose in submitting the amendment was to document construction changes and to document compliance with their plat that had been approved after the original CA. But then after the public noticing went out, we were told and we confirmed that the change in the driveway width and the sidewalks had not been completely documented by a variance or by planning commission action. Therefore, we realized we should not have approved it because it did not comply with its underlying zoning at that point.
So if you had known at the time that the property was not in compliance with the zoning restrictions and requirements.
But with the plat restriction.
With the plat restriction and requirements, then you would not have been able to issue?
Correct. Just on, yeah, well, yes.
So, but that only, so that's why when you issued the corrected approval, it only addressed that issue, is that
correct? Correct, because that was the only item we believe to be in any sort of error.
Everything else was in compliance with the plat?
The plat didn't address the rest of the issues. The other issues are exclusively design regulations and guidelines that are under the Cottage District Ordinance.
So this is the first time this has happened that you can recall?
That what has, what exactly?
That you've issued, I'm sorry, that you've issued a CA essentially and then withdrawn it and then reissued. That's the first time that's happened?
We have issued other corrected CAs.
Do they typically fall within the time frame to appeal?
I can't say without looking at them.
But it is your understanding, the reason that you issue those is because it's your understanding that this notice and appeal ordinance exists, and so the CA being issued and notice to everybody is essentially for that purpose.
Correct.
Can I just get a clarification under the ordinance regarding the mailing? The mailing was a courtesy copy, is that correct? Or was it required by ordinance to mail to any other parties besides the applicant?
The noticing of administrative approvals is not explicitly codified. We began it in July 2015 as it's more than a courtesy. A courtesy is not quite strong enough, the word, but there has always been a 10-day appeal period on administrative approvals. That is in the ordinance. There was a question of how does anybody know that clock is ticking? And so early last year, I guess 2016, July 2016, sorry. Early in 2016, we developed a process to notify the property owners within 150-foot radius.
Thank you. Don't go anywhere.
Well, attached to our response is an email from Lisa Chronister to one of our Neighborhood Association board members, Brian Fitzsimmons. And in the email she says, yes, the corrected CA would have a new approval date and therefore a new appeal period. If you'll notice on the January 9th corrected revision number 1, there is a note that says work may not commence until after the mandatory 10-day appeal period starting from the date of approval. So we could have challenged any start of work that took place before January 25th as being in violation of the January 9th revised certificate of approval.
Now, they could have started work before that time because the time
At
had
their own
run
risk.
as to the first one, and they could have started and commenced every one of those, James.
Well, and that's...
Oh, no, I disagree.
No, I'm bothered by that. I'm bothered by that because if you have a development that's ongoing and you're trying to go through and check and you've got a schedule that's held up or something like that, or contractors that are on standby, when that period runs, you're going to go to work. I mean, we can agree that that's pretty common sense, right? I mean, that's the reason that there's an appeal deadline for stuff like this is to give everybody the certainty that they can proceed without fear that they end back up here fighting to be able to do what they've already done. You agree with that?
I agree.
Okay.
The problem is they didn't begin in the 10 days after the December 19th decision because they knew it was no longer valid. And they knew there would be a new 10-day appeal period, just like city staff told us.
I don't think whether they began or didn't begin is relevant to our discussion here.
I think it's very relevant to the discussion. I mean, they are what in case number 5 here on our agenda, what we're deciding is whether or not we can even technically hear the merits of what's going on. And I'm bothered by that because if we get this wrong, everything else we do is essentially irrelevant. Yeah. Because we're going to go to district court on that issue alone. So what I'm trying to do is get certain, and those things are imperative because the public relies on those things to be hard and fast. And this is a real interesting gray area here.
No, my point is I don't think that whether they physically began construction impacts that one way or the other. If
they had started construction under the ordinance, you don't think that they would be aggrieved by that they're back here. They've started relying on that approval. They took action after that notice period had run. You don't think that they would have a grievance?
They would be aggrieved in the sense that they'd be welcome to come here and talk to us about it, but would that foreclose the question of whether or not the appeal time had run? No, I don't think so.
No, I'm not saying whether it would run, but his argument is, and this is really what I'm trying to ultimately dig into, is this is really unfortunate because when that first CA was issued, everything about that CA was legitimate from the standpoint of creating that notice within the confines of the ordinance. Okay, if I say something you don't agree with, just you interrupt me. That's okay. And then we have a revocation or withdrawal. We're going to use different terms because it's not codified anywhere. There is no policy for this. And then it's pulled out. So if I'm on the other side, I don't know what to do with this. I've been approved. I'm holding it in my hand. There's a list saying all the things that I can now change about my development. There's a 10-day notice period, and then it runs, and it's over. Well, then a new one is filed or given by staff, essentially reissued or corrected, and at that point, there's an appeal filed. So it is, in my view, imperative on two fronts. One, that is a hard and fast for a reason. It's to prevent that. And the other thing is that if there had not been a revocation, we wouldn't be here, or a withdrawal, we wouldn't be here either.
Okay, so I understand all of that, and I understand what you're saying, but I think the question of whether or not there was a revocation and the issuance of a new, different certificate of approval amendment is a question of law, not a question really of fact. It doesn't have anything to do with whether they proceeded or didn't proceed with the construction. I mean, does it make it more difficult or harder or, unfair or whatever? You could certainly argue that it does or does not, whichever side of that you're on, but I don't think that that's what's controlling. Let me see if I can state where I think we are, and then we can argue about that for a while. It seems to me that staff issued a certificate of approval amendment, and there's question about whether they had the authority to do that in the first place, but we're not quite there yet. And then at some point, they believe they withdrew it and issued a new one. And I think they communicated that belief to the appellants, and that appellants relied upon that communication to wait to file an appeal based on that statutory 10-day appeal time. And, I think that everybody can kind of agree on those facts. The question is whether it matters, whether the appellants have a right to rely on the city's however in good faith or well-intentioned assertion that one was being withdrawn and another one issued, and that the issuance of the second started a new appeal time. And I think that is an entirely specific question of law. And, whether whoever did what and what difference it made, whether that affects that 10-day appeal time or not, is the question that's before us on this motion to dismiss. And to me, it's sort of the threshold question. It's the most narrow and specific question that we've got to decide today. If we get past that, then it's, there's a whole other thing. But I think, and I'll just say this for what it's worth, in my own experience of dealing with the law as it relates to the Board of Adjustment and appeal times, it's pretty harsh. It's very specific, it's very short, it's very narrow, and if I remember correctly, it's been pretty uniformly upheld.
I have, to your points, I have a question for Mr. Box and your side. When did you receive notice, and how did you receive notice that the first CA had been revoked/withdrawn?
I don't know the specific date that my client, I wasn't involved. I know staff told them what they were going to do. My client called me and said, "Is this right?" And I said, "No. They can't take back something in which the appeal time has run. What date that actually happened, I'm not sure. I wasn't involved. I believe somebody at staff may have said, we've got the one issue, we're going to issue a new one. But I'm not sure of the date.
And my point, I guess, that I was trying to make to you is whether they, on the day that the first appeal ran, went out and started doing whatever it was they could do pursuant to it, doesn't improve their position. And the fact that they didn't do anything does not improve the position of the appellants. I don't think that matters.
I do have a question of the municipal counselor, though, if I may at this time. Madam Chairman. Municipal counselor, I have some questions regarding this application process. So the original certificate of appropriateness revision there's a provision to allow that to be issued in this particular case. And the appeal time runs in 10 days, is that correct?
Yeah, it is a 10 business day appeal period.
And that is as per statute, which defers to city ordinance, is that correct?
That is correct. It refers to specific time frames set out in the ordinance.
Okay. With regards to that time period, when that time period has run, which in this case is either the 5th or the 6th, in any event, it's one of those 2 days. I have the 5th. But what happens after that point in time when that time has run?
Then it is final and building permits can be issued.
And so building permits can be issued, and that puts into place the running of the appeal times, that forecloses any later appeal times. Is that correct?
Correct.
I want to be clear about that. It's not the issuance of the building permit that forecloses it. It's the actual expiration of the time.
The expiration of time. Yes, ma'am.
I guess, I don't want to belabor this point too much, but there are other aspects to the requirement that are equally, difficult to live with. You have to file a copy of the appeal with the city clerk, as I recall, and failure to do that's been found, jurisdictional. And it's a very specific set of guidelines. It is harsh, it is short, it is narrow, but it is what it is. So I think that's what we have to decide, whether we believe that the fact that staff told the applicants that there was a new appeal time running and that they relied upon that.
I believe I heard that there's an email from Lisa that verifies that commitment was made.
And so whether or not the fact that was relied upon by them affects in any way, shape, or form the actual appeal time, whether the statute is affected by that, or whether they have a right to rely on that in a way that affects that running of time is to me the most important.
It sounded definitive to me. They were told that the clock started.
Who was told?
The neighborhood association. He referred to an email that was sent to a member of the neighborhood association by Lisa.
And I think we all agree with that was done. My point is that whether the fact that it was done affects in any way that jurisdictional requirement.
I'm not an attorney, so some of this is, I'm not familiar with all the terminology. But to me, if somebody, tells me and there's a written confirmation of the new effective date, then for me it would be pretty clear-cut, when the clock starts again in terms of when my appeal deadline was.
Chairwoman, may I make a couple comments?
Sure.
I would just point out that the email from Lisa Chronister to Brian Fitzsimmons with the Neighborhood Association Board was on January 3rd, before the deadline had run on the original December 19th, if it was effective. I think that's important because the Neighborhood Association was ready, willing, and able to file an appeal on January 5th or January 6th, whatever the deadline day was, and we were told by staff not to do it. Now, I also need to point out that this email from Lisa Chronister is not the only evidence that there's a different time frame here. If you look at the January 9th decision, the corrected revision to the CA, it says we have 10 working days to appeal the January 9th decision, and the developer can't start work for 10 days after the January 9th decision. So if you say the appeal time ran on January 6th before this was even issued, you're changing the text of the January 9th certificate of approval issued by staff, because it says there's a 10-day window to appeal the 10 items that are listed there.
And I think what I'm having trouble with there, and I'm frankly equally bothered by that as I am some of the other things here, but it's that at the end of the day, when it was approved and signed and staff issued the CA, that's what the ordinance recognized, right? And ironically, which is very, very troubling for a variety of reasons, they don't have to give notice technically, apparently. That's news to me today. But that they can sit, that clock is running in the background and they don't even know it, is very, very troubling. At the same time, all that we can do as members of the board is look to an ordinance, and maybe I'm a stickler for that, okay, but I'm looking at these definitive things and I'm going, at that point, everything else that was done in error.
Well, may I interrupt?
Yeah.
We're going to have to get into the weeds a little bit here, because our position actually on the merits is that city staff had no authority to revise that certificate of approval. There's nothing that allows, in the code, there's nothing that allows the city staff to revise a certificate of approval issued in the Cottage District.
I have to stop you there, because it's not, we don't have to get into the weeds. This question is a threshold question.
Yeah.
Well,
and whether or your ability to challenge the city's issuance of the original certificate of approval amendment may have expired on whatever that date is, January 19th, is that it?
How can it expire if it was void when it was issued?
Your ability to challenge it may have expired. And that can happen whether it was valid or not.
This is a serious violation of due process when we start talking about timeframes running without notice, when people are told by the staff who issued the original revision, the same staff who issued it, that it doesn't apply and they need to wait for the next one to file their appeal. I mean, there's all kinds of due process violations there.
I agree. It's a very, very difficult situation. I mean, I do. But again, and I just have to come back to this, I'm not sure how difficult it is matters on a jurisdictional question.
Well, we have a constitutional right to due process, so it matters very much.
Well,
and I think the district court and other courts would put a lot of weight on our due process rights because they're from the Constitution. So
I have a question.
Yeah.
You have the written document and you have the written law that determines how you can appeal the adverse decision, and you have statements by other parties. What controls in district court, the written law or a statement by somebody saying, well, we'll hold up your motion, we'll hold up your trial? What controls? Doesn't the written document and the written law control?
Well, if it hadn't been withdrawn by the very people who issued it, we were told it's withdrawn, so there's nothing to appeal. If it's been withdrawn by the people who issued it, who have the authority to issue it, then there's nothing to appeal.
And to his point, I mean, I know that Brian Fitzsimmons doesn't necessarily, at the time, doesn't necessarily represent SOSA, right? But he's on the board. But he's also lives in the area, so he's kind of concerned resident.
Yes.
Is that?
That's correct.
Okay. And so, I mean, he specifically asked the question in the email that basically asking them to clarify that this would require another 10-day, and that's clearly 3 days before the time would have run for that appeal. That's very troubling.
That could have been a simple filing the appeal and then refiling it again to follow the ordinance and the law.
Yeah, and as you know and we know, emails can very quickly be taken out of context by taking a snapshot of something. And so I am not purporting to... This is not a problem that Lisa created, okay? But what I'm getting to is it's troubling in that, on the one hand, I'm troubled that there's a very clear directive in the ordinance that forecloses the right of appeal beyond a set time frame, that specifically addresses the area at issue here. And there was, on the flip side of that, there was people clearly trying to figure out what to do to appeal it. And we recognize there's this short window. So you're sort of clamoring in the background trying to get all this together, and you get an assurance that there's going to be a new issue period. It's very real. It's very, very human to take that at face value and go, okay, I've got time.
And it wasn't just a verbal exchange. There's written documentation that commitment was made.
And if I could, I mean, when you look at the email, they've redacted a portion of it. And what they redacted, we received today, Mr. Fitzsimmons responded back because this to him left some answers. He wanted further clarification. And what Ms. Chronister says is, after he sent the email asking further clarification because it didn't address the issue like he thought, there was a phone call that happened. So perhaps they relied on staff. They shouldn't have. I mean, this is a neighborhood with multiple lawyers. Why they relied on a planner and didn't reach out to the city attorney, didn't look at the statute, and just to save their appeal time, go ahead and file a notice of appeal that day while you're still within the window. I mean, this is a sophisticated group of neighbors. And those deadlines, Ms. Powers is correct. Although harsh, that's the law. It's equally harsh to allow this indefinite appeal time to be opened every time there would be an error. And it's evidenced by every other time the city's ever corrected a CA, they've never impacted the effective date. Because legally they can't.
But
so
here
this is
they
the only
did.
time they've ever tried to wrongfully change the effective date. It wouldn't matter if she stood on top of City Hall and screamed as loud as she could, I hereby revoke the CA. If she doesn't have the legal authority to do it, it's ineffective.
How do the people who issue the document not have the authority to withdraw the document? They have the authority to issue it. They should have the authority to take it back. It's the same people.
A district judge doesn't after his time has run out. If a judge issues an order, a judgment, you have a certain time period that the judge has control over in the jurisdiction over the case. Is that correct? But after time runs on that, the judge does not any longer have control to amend or change.
Oh, I disagree. Judges do things like that all the time. People can come in and file a motion to go back and correct errors or new evidence comes to light. Judges have complete discretion over things like that.
Under the newly discovered evidence statute.
Well, that's just the general jurisdiction of judges. They have the discretion.
Well, but this isn't judges, and it's not court. The issue that happened here was staff issuing an approval. Whether or not they had the right to do that is beyond the merits of where we are at this point in this hearing. And I am very confident about one thing and one thing for sure. No matter which way we go, it's the wrong answer. In the sense that it's going to go beyond that either way, because each side is going to rely on this. But I'll say this, for me it is determinative that the ordinance on point gives a very specific hard date which basically forecloses our ability to hear the case. So I'm troubled by a lot of aspects of it, but that's all I can hang sort of my hat on, if you will, on this, is that I don't believe that I have the ability to hear it, and I'm deeply troubled by that, especially given the circumstances that surround this.
Why do you think the January 9th decision that was issued by staff is exactly the same as the December 19th decision? There are very clearly differences.
There is no process that we have been pointed to or directed to, or that is a formal process of staff, even if not codified in the ordinance, where an approval of a CA can be revoked, withdrawn. We've been told that corrections have been issued in the past to address things like clerical errors, typos, never the withdrawal of an item on that on that CA. And so if they issued that CA in error, which was what Ms. Chronister testified to us, was that they realized that conflicted with the plat, so they simply reissued that. I think she did that as, by her admission, and of course there's nothing in the code that we can point to, it was essentially a second courtesy. When they issued the first approval, that clock started running. And after 10 days, the ability to appeal it foreclosed.
Well, why then, when they issued the January 9th decision and said a new 10-day clock is running, didn't a clock run on the January 9th decision?
I think that clock had, on January the 6th, assuming we can agree that's the date with the holidays and all that sort of thing, if that's the date, that's the point where it was over. If another approval was issued, in my view, it was issued in error, and it's not something that we can consider because the ordinance tells us after 10 days, the right to appeal has been foreclosed.
Okay. I think, again, come back to where I started. I think we are in agreement on sort of what's happened here in terms of the factual process. And really, it seems like equally clear to me that, whatever is decided here today is probably on its way to district court. So I will ask both members of the board and the appellant and the appellee, if they would care to offer an opinion on the subject, whether you would rather take this case to district court on the basis of a decision on, well, I guess it would only go that way in the event that it was denied, but, on the question of jurisdiction, or whether you would rather have it heard today and develop an actual record on the merits of the case and take the whole package.
I believe it's jurisdictional. We want an answer on that.
Okay. How about you?
Well, I believe a decision to dismiss it based on the motion to dismiss would violate our due process rights. We'd rather have it heard today on the jurisdictional issue because if there was indeed, as we assert, no jurisdiction to revise it administratively in the first place, then the certificate of approval issued on December 19th was void anyway.
Okay. Stop.
Just a couple of questions. The authority of planning department to withdraw the December decision is disputable. There's a question about whether they had the authority to do that.
Well, I think there's a question as to whether they had the authority to issue it in the first place.
Okay. Well, if there's a dispute about whether they had the authority to issue it, there's certainly a dispute about whether they had the authority to withdraw it. Here's what I would say, and this is just from a practical, and again, I'm not an attorney, but if I saw it issued and the planning department withdrew it promptly, I would assume that they had the authority to withdraw that in its entirety. And if I was told that, that my appeal window was going to start from this new date, just my good faith and being told, and having the truth represented, I would have a tendency to accept that and not question it or not challenge it. And it may have been naive, for them to have accepted that and at that time. I don't know. But just as a layperson, that's, it seems pretty straightforward. I can understand, David's argument, and I can certainly understand yours. If I was in your position and I had been told that, it was being reissued and here was my new window, and then I appealed within that window, I would assume that I was safe. So, I don't know, at what point, and where this is going to pivot, but my tendency is to be sympathetic to you, because just if somebody had told me, that this is, we withdrew it, we reissued it, here's your new window for appeal, I would have a tendency to accept that as a factual statement. But I also understand that you argue whether planning had the authority to do what they did, and therefore, from the December date, that's your start window. They're outside it, so therefore they don't have the right to appeal.
And we can, our hope is that the board dismisses it, but the idea that they wouldn't have the authority to issue it runs contrary to all their practice for years and years and years. But I absolutely understand your point. And if the people that were meeting with staff weren't lawyers, perhaps I'd have more sympathy. But if I was over at the 9th floor, and this is no disrespect to anyone on the 9th floor, but if I was at the 9th floor and I have the 10-day window, which I have firmly in my mind, anytime somebody walks in my office, if staff told me I'm going to issue a new one and open up the appeal window, you know what I'd do? I'd walk over to Development Services, go ahead and file my appeal anyways, just to preserve my rights, because I know what the statute says and what the ordinance says. And although staff perhaps gave them some wrong advice and didn't consult with their attorney, that's too bad. But there's no provision in the statutes or the municipal code for bad advice from a planning staff member.
I have a few comments. Number one, you asked a question about what board thought with regard to hearing the whole merits of the case, is that item B, and the other. We have heard from the municipal counselor's office, and I concur, of course. The first document that was filed had an appeal time. That CA had an appeal time of 10 business days or working days or whatever you want to call it. That notice was mailed to the appellant here, and they had the written document before them regarding that. They were on notice, written notice, both under code, city code, and state law, that they had 10 days. But we only have jurisdiction to determine, we have jurisdiction to determine our jurisdiction. And we're not looking at all the underlying facts. We're looking at the facts of the filing, the appeal time, and the remedies. And in this particular case, we have jurisdiction to determine our jurisdiction. I don't think we have jurisdiction in this case because the appeal time did run. So basically, that second revision, I was like trying to revive a corpse. It wasn't there, the time had expired.
In response to the question I asked, you think we should decide on the question of jurisdiction?
Correct. So my answer is we should decide on the question of jurisdiction and not hear the merits today. Now?
I mean, council's torn, I'm torn, they're torn. I don't think we have jurisdiction to hear it. If council was in agreement to hear it, we got nothing to lose. I mean, it's going up there regardless. So, but it's very troubling. I don't see how we get to jurisdiction under this book.
Madam Chair, I've signed up to speak on this matter. Am I entitled to before we decide the issue?
You certainly are.
Thank you. Good afternoon. My name is Bill Bleakley. I live at 607 Northwest 7th. I love the term. There's a lot of clamoring in the background on this. There certainly was. This initial revised certificate of approval came up, I think, on December 19th or something in that realm, hit right in the face with the holidays. Members of our neighborhood, by the way, I'm on the board of directors, so I'm both being a representative of the association. We received of that, members of the neighborhood, some of whom are on the board, immediately started analyzing the thing and looking at the prospect of having an appeal of it. During that process, they began communicating with the planning staff and was told that, well, this has been revised and there's a new one out. Some point in that effort, I got involved too, dealing with planning staff on what was the final date of the deadline, because there was some issue as to whether it was January 24th or 25th, and we didn't want to blow our deadline. The document that I was dealing with in my analysis of the case and working with planning staff on our appeal process, I was dealing with certificate of approval revised number 1 corrected. And on this, it has the effective date of the appeal period and it has all 10 listed, and there's no place on here that says all these 10 are already approved, and the only thing you have to worry about is the elimination of the provision for a narrower private access drive. So we began working on our appeal. I noticed down here that it says they've got, you may not commence work until the mandatory 10-day appeal period is starting. It didn't say, well, everything on here has already been approved, so don't worry about it. You can go ahead and do your work. So throughout this process, in my conversations on appealing, nobody ever informed me of anything different than we had a valid right to proceed appealing the matters that are on this corrected deal. I think we've really got a real situation of detrimental reliance here, and as we have said in our case in chief, we don't think the staff has the ability to issue these things in the first place. So we have so many nuances of these issues. We, from the get-go, had a committed desire to evaluate the certificate, determine where we should appeal it, and prepare our appeal, and we move forth in good faith. So I would urge the board to deny the motion to dismiss. Let's hear the merits. And there's another reason for this. There's talk about going to district court. District court is going to take both sides a lot of time and expense. These guys want to get started on their project. The neighborhood wants to resolve the issue. We just want our day in court before the Urban Design Commission. So we ask you, please rule in that regard, and I urge you to either remand it or dismiss their certificate, rescind the certificate, so that we can go back, get this thing done, and not proceed off to district court and conceivably have to go back and do all this all over again. Thank you.
I may regret this, but anybody else?
Is there a negative consequence to consider remanding it back to urban design?
Oh,
There's no authority to do so.
So you're saying that, you know, in essence, the December 19th date, the clock ran when the 10 days were over. It basically doesn't allow us to consider this matter, and that we do not have the authority as a board to remand it to urban design?
Essentially, that's correct.
And the Planning Commission acted outside the authority?
That certainly is the question before us, you know.
But the planning, they had the ability to go back and correct clerical errors and things of that sort, but they acted beyond their authority when they said that they withdrew and reissued on a new date, a revised document.
Right, wrong, and different, when they issued that CA, even if they didn't have the authority to issue it, as the merits of this case would seem to suggest, that's when a party, the party being neighbors and people with, you know, basically an aggrieved party, had 10 days at that point to file an appeal on that decision. There is no requirement, as stunning as that is to get a hold of in your mind, that these people be noticed. It's done as a courtesy, and in this instance, no good deed goes unpunished. So when that went out, and then it was revoked, and then there was an email exchange and confusion, and then it was reissued, all of that is not, unfortunately, for us, it's not relevant. Because the minute that it was issued, according to the ordinances, that's what aggrieved those folks, and that's what gave them that 10-day window, and it wasn't filed within that 10-day window.
But I've got to give some weight, you know, some consideration to you know, what was said in good faith.
You can't. And I'm deeply troubled by that the way you are, I assure you. But a court without jurisdiction cannot hear the merits of a case either. They will dismiss the case because they do not have jurisdiction, whether it's in personam, in rem. If they don't have jurisdiction, they don't have jurisdiction. By our ordinances, what we are charged with from the city council to uphold, we do not have the authority to hear the merits of the case.
All right, neighborhood, you know how I feel about this. I'm a non-attorney, everyman who would have a tendency, even though you had attorneys or had access to attorneys, that if they told me, that this was what was going to happen and we felt like we understood and that a commitment was made to us, that I would, act with that information. But what I'm being told is that, we do not have the jurisdiction and that perhaps, at the next level.
Well, I disagree a little bit with Mr. Cravens. We're not appealing the December 19th Certificate of Approval, Revision Number 1. We're appealing the January 9th Certificate of Approval, Revision Number 1, corrected, which said on its face that we had 10 days to appeal and then no work could start.
And the authority of planning to do that.
Yes.
And that's what I'm being told. That's what I'm hearing.
But I think the extension of that argument, if you're being consistent, is that by that time, by the time they actually filed, the initial certificate had become effective. And their attempt to revoke it, if you will, or their attempt to create a new filing deadline, appeal deadline, was ineffective. If you believe that appeal time is jurisdictional, then I think we are deprived, and I would put it that way because, I am not expressing any opinion about the merits of the case. I feel deprived of the ability to do that.
And I understand that. What I'm saying is that, these folks are lay people like I am, and they're not attorneys, and they accept in good faith, what their understanding is of what's represented. So I understand why you feel like you've got this. Not being an attorney, the rest of the board is, and David, and I respect David, and I respect you, and they're telling me, where our authority begins and ends, and what the outcome is likely to be at district court. And so I understand completely why the neighborhood, would have acted and felt like they had that commitment and that commitment was real.
I just have one last comment, which is it's very hard for me to get my head around the idea, and we don't have any guidance from the code, so we just have to think through it. But if the planning department staff indeed had authority on December 19th to issue a revised CA, then surely they also had the power to withdraw it. Now, there's nothing that says they have the power to do that in the first place, but if they do have that power, then they ought to have implicit within that the ability to withdraw their own decision. It's not like it was a UDC commission or a Board of Adjustment commission decision. It was their decision. And I don't understand how the planning department could not withdraw something that it did on its own.
I think perhaps that question, for me at least, is a little bit complicated by the fact that the only issue that changed from one to the other is the one issue, of course, that's not being appealed. So even if you accept that logic, if you will, the internal logic of the transaction, nonetheless, all of the items on the certificate of appeal amendment that you are appealing were covered by the original certificate of appeal amendment.
But if it was withdrawn, then it wasn't effective. And that's what I'm saying. Implicit in the authority to issue something is the authority to withdraw it.
Yeah, but
we were told it was withdrawn.
But to your point, we don't even really know if they had the authority to issue it.
I agree. I know.
Right? That's it's a totally circular deal. And
yes.
and again, there's some interesting discussion here inside of those merits about whether or not they had the authority to issue what they issued. But we can't even get there. It was that, and you know this, the minute it was issued, that was the grievance that triggered this limited period, this limited little area of ordinances that we have to work within that I can't get around.
But just hypothetically, if they had authority to withdraw a CA, then that appeal time and the entire CA went away when they withdrew it.
Yeah,
I'm not saying that happened, but I'm saying hypothetically.
We're not going to decide that. I think, for me, I guess, there's no question about the equities of the case, you know, and maybe this is the great disadvantage of having 3 lawyers sitting up here. But jurisdiction is not an equitable issue. It's, you know, a matter of law, and it's very specific, and it does not permit us to entertain the equities of the case. So, however difficult it is, I think I'm going to call for a motion.
I'll make a motion to, let's see, I'm getting confused now about who's the appellant. I'd make a motion to grant the request for a motion to dismiss on the grounds that we don't have jurisdiction to hear the case.
I would like to, is there any way I could amend that? I can try. Basically, with respect to the motion based on the findings of fact as enumerated in the applicant's motion to dismiss and amend in response, and based on statements of the municipal councilor, the findings are clear that the appeal time had run 10 days from the issuance of the first certificate of approval, and having run in the 10-day period, which would have been, as stated in the letter, January 5th, the right to appeal before this board had expired, and therefore there was no, and the findings, or therefore there was nothing else to act on, and we have no jurisdiction before us because the appeal was filed untimely. Further, for the record, the parties have acknowledged they did receive that first CA revised, and so they were on written notice of the appeal time.
I hope I don't have to repeat that. So I'll just be the second.
Okay, I have a motion and a second, and I'm just going to say to grant the motion to dismiss. See if I can find something that's got a case number on it really quickly for my record. In case number 14332, would you cast your votes, please? And it carries. So now, what do I need to do about the other? Does it just fail? Okay.
Would you entertain a motion to dismiss
I
or
would
adjourn?
entertain a motion to dismiss.
Do we have a second?
Second.
I have a motion and a second to dismiss. Would you cast your votes, please? To adjourn, I'm sorry, to adjourn, to dismiss. We're adjourned.